Imagine you are standing trial, facing, I don't know, years in prison for a regulatory crime.
Right, a highly stressful situation.
Exactly. The trial takes months. You're paying lawyers, the prosecution is mounting its case, and the stress is just unbearable.
Oh, absolutely.
But then, literally the day before the judge is scheduled to drop the gavel, the legislature silently deletes the very law you broke.
Just poof, gone.
Yeah. They don't announce a pardon. They just wipe the statute from the books entirely.
Wow.
So, do you still go to prison because you broke the rules when they were active? Or do you just walk free?
It is a scenario that sounds, honestly, like a Hollywood legal thriller.
It really does.
But it represents a very real, very mechanical function of our legal system. We tend to view the law as this, immovable architecture.
Right.
But it is actually highly susceptible to sudden, dramatic alteration.
Which is the core mission of today's deep dive.
Mm.
We are shattering the illusion that the law is a rigid structure carved into stone tablets.
Yeah, society's way too messy for that.
Exactly. Society is messy and dynamic, which means the legal framework governing you has to be a living, breathing, and constantly shifting ecosystem.
Precisely.
We are pulling from a really comprehensive legal document today, Unit 5 from Pro Legal Minds.
It's a great source.
It really is. It details the intricate life cycles of statutes. So we are going to explore how laws are altered, how they are completely destroyed, and what happens when different laws battle each other for supremacy.
It's a wild ride.
It is. Okay, let's unpack this.
What's fascinating here is how invisible this life cycle often is to the average person.
Yeah, most people don't even think about it.
Right. Yet it fundamentally impacts every calculation you make, whether you are structuring a commercial contract or running a supply chain.
Or just managing your personal liabilities, right?
Exactly. The rules governing your behavior can be modified or erased at any moment.
Which is terrifying if you aren't paying attention.
It is. Understanding this dynamic landscape is crucial because you cannot protect your own rights if you don't realize the rules of the game are, updating in real time.
So true. To really understand that shifting landscape, we actually need to start at the end of the timeline.
Right, the death of a lawyer.
Wiping the legal hard drive. The mechanics of repeal. According to the source, legislatures have 3 primary methods for executing a law.
Yes, they are express, implied, and partial.
Right. Let's look at the mechanics of the most direct method first, which is express repeal.
Yeah, this is basically an explicit assassination of a statute.
I love that phrasing.
It's true, though. The legislature passes a brand new law, and within the text of that new law, it explicitly revokes the previous act.
The source points to a very clean historical example of that from India, actually.
Oh, right, the 2004 case.
Yeah, in 2004, the Indian Parliament enacted the Unlawful Activities Prevention Act.
Often called the UAPA.
Right. And buried in that legislation was a specific clause repealing the older Prevention of Terrorism Acts, or POTA, from 2002.
So there was no ambiguity there.
None at all. The new law basically pointed a finger at the old law and formally ended its existence.
And that level of clarity is ideal for the legal system.
Sure.
But the friction arises with the second method, which is implied repeal.
This one is tricky.
Very. This happens when a legislature passes a new law that completely contradicts an older law.
Or it regulates the exact same subject matter in a totally incompatible way.
Exactly. But they never actually bother to state that the old law is canceled.
So you end up with 2 active laws on the books demanding contradictory behaviors from the public.
Which is a nightmare.
I was looking at the 1875 House of Lords case, the text cited, Taylor versus Taylor.
Oh, yeah, a classic example.
The court basically ruled that if the new statute is completely irreconcilable with the old one, the newer legislation wins by implication.
Right, the old law is impliedly repealed by its silence.
But the courts actually despise doing that, don't they?
Oh, they hate it. Judges operate on a strong presumption against implied repeal.
Because it forces them to guess what the legislature was thinking.
Exactly. It forces them to guess the intent. Their first move is always to try and harmonize the 2 conflicting laws.
Like, find a way they can coexist.
Right. But if the contradiction is absolute, if complying with the new law means literally violating the old one, the newer law acts as a silent killer.
A silent killer. That is an unsettling concept for anyone trying to maintain compliance.
It really is.
So the third category, partial repeal, feels much more manageable.
Yeah, it's an amputation rather than a full execution.
Right. For example, when the Information Technology Act was enacted, it didn't scrap the entire Indian Penal Code.
That would be chaos.
Total chaos. It simply excised and altered the specific provisions relating to defamation to account for the digital age.
Right? The rest of the penal code kept functioning normally.
Which makes sense. That surgical approach is vital for continuity.
It is, but when a full repeal does happen, whether express or implied, we have to confront the systemic aftermath.
And this brings me back to the hypothetical scenario we opened with.
The trial.
Yes, the trial. I need to ground the concept of a full repeal. Is repealing a law like throwing a file in your computer's trash bin?
Like it's removed from the desktop, it's still there.
Yeah. Like if the state really needs to prosecute someone for a past action, can they just open the trash bin, hit restore, and use the old law?
Or is it like taking a magnet to the hard drive?
Exactly. Are they wiping it entirely?
Well, the jurisprudence actually leans heavily toward the wiped hard drive.
Really?
Yeah. The source material highlights a definitive Supreme Court case on this Gajraj Singh versus State Transport Appellate Tribunal.
Okay, what happened there?
The ruling established that when an act is repealed, the legal fiction is that it must be considered as if it had never existed in the first place.
Wow. So it is obliterated from the parliamentary record?
Pretty much.
But surely that obliteration can't be absolute. I mean, if a business was fined and paid that fine under a law 3 years ago.
The state isn't cutting them a refund check today.
Right. Just because the law was repealed.
You are identifying the one vital exception here, which is past and closed transactions.
Okay, that makes sense.
If a case was fully prosecuted, decided, and concluded while the old law was active, the finality of that judgment is protected.
So the past stays closed.
Exactly. But for anything moving forward or anything currently pending,
The hard drive is wiped,
the hard drive is wiped.
which answers our opening question perfectly. The source specifically details a fascinating case regarding the Andhra Pradesh Liquor Prohibition Act.
Oh, the Jagmander Das case?
Yes, State of Uttar Pradesh versus Jagmander Das. It makes the precedent very clear.
It does.
If you are caught possessing liquor when a ban is in full effect and you are on trial, but the legislature repeals the Prohibition Act before your verdict,
The prosecution simply ends.
you walk completely free.
You do. The court held that continuing to prosecute you would amount to the state enforcing a dead law.
Because the state's authority to punish derives from active statutes.
Precisely. The moment that statute is repealed, the authority evaporates instantly.
So is there any way a prosecutor can keep a trial going?
The only way a prosecutor can keep a pending trial alive is if the legislature specifically included a savings clause in the new legislation.
Like a bridge between the old and new law.
Exactly. Without that explicit bridge, the gavel drops, the case is dismissed, and the defendant goes home.
It fundamentally reframes how we view state power.
It really does.
It isn't just a set of moral decrees. It is a highly technical mechanism that requires constant active authorization.
Right. And wiping the legal hard drive through a full repeal creates massive administrative shockwaves.
I can imagine. So legislatures often prefer surgical interventions, right?
Yeah, patching the bugs in the system rather than throwing out the whole software.
Which brings us to the evolution of a law, amendments.
Amendments are basically the vital software updates of this ecosystem.
Right.
And the source categorizes them into two distinct operational buckets, substantive and procedural.
I want to make sure the distinction here is crystal clear for the listener.
Sure.
So substantive amendments change the actual meat of the law, right? The specific rights, duties, or obligations a person or a corporation holds.
Exactly.
The text uses the Indian Companies Act of 2013 as an example.
That's a great example.
The Parliament passed a substantive amendment imposing mandatory corporate social responsibility obligations on certain profitable companies.
That is a perfect illustration. Overnight, these corporations were handed a new substantive legal duty to allocate a percentage of their profits to social causes.
It literally altered what they were legally required to do with their capital.
Right. Now, procedural amendments, on the other hand, don't change the what.
They changed the how.
Exactly. Procedural amendments modify the administrative mechanisms.
Like how those substantive rights are asserted?
Or how remedies are actually processed through the bureaucracy. The source details an amendment to the Civil Procedure Code in India.
Oh, the one about alternative dispute resolution.
Yeah, they made things like mediation and arbitration a mandatory pre-litigation step.
The goal being to clear out massive backlogs in the physical court system.
Right. Your substantive right to sue someone didn't disappear.
But the procedural pathway of how you get to stand in front of a judge was completely re-engineered.
Exactly. Now, modifying those pathways is relatively straightforward when applied to future
For
cases.
sure. Going forward, it's easy.
But the friction point in the ecosystem, and honestly one of the most contentious areas of administrative law, is the temporal application of these updates.
Okay, this is exactly where I want to push back.
Go for it.
The source dives into retrospective amendments.
Yeah.
It is one thing to announce, hey, from this day forward, these are the new rules. But applying a new rule to past events,
It's controversial.
it completely destroys the concept of reliance. If I'm running a business, I make financial models based on the law as it is written today.
Of course you do.
If the legislature can reach back in time and change the rules of the game while the ball is already in the air, how does a capitalist system maintain any predictability?
It's a valid point. The tension between individual reliance and systemic progress is profound.
It feels inherently hostile to fairness.
It does. But sometimes, the courts determine it is absolutely required to prevent even greater systemic inequalities.
Okay, how so?
Well, the source points us to a landmark 1970 Supreme Court of India case to illustrate this. Narayanan Namboodirpad versus State of Kerala.
This was the land acquisition dispute, correct?
Yes. The government was acquiring massive tracts of private land, which naturally generated a flood of disputes over the compensation rates.
Right.
While thousands of these cases were stalled, just pending in various courts, the legislature amended the compensation rates in the underlying statute.
So the property owners who filed their lawsuits months earlier under the old rates naturally argued,
You cannot apply the new financial metrics to us.
right, our transaction started under the previous regime.
And under your reliance argument, they would be right?
But they lost.
They did. The Supreme Court held that the amended compensation provisions must apply retrospectively to all pending cases.
Why? That seems so unfair to the people who filed early.
Consider the alternative. If the court strictly locked in the rules at the time of filing, you would create an administrative nightmare.
How bad could it be?
Well, imagine two neighbors whose land was seized on the exact same day. They might receive vastly different financial payouts simply because one neighbor's paperwork cleared a clerk's desk the day before the amendment.
And the others cleared the day after.
Oh, wow. Exactly. It prioritizes consistent, equal application of the updated framework over the strict chronological timeline.
It forces the ecosystem to adapt backward to ensure nobody is trapped in a defunct version of the law simply due to bureaucratic processing times.
It is a really delicate balancing act. The ecosystem is constantly reorganizing itself chronologically.
Well, here's where it gets really interesting.
Oh, yeah.
We've looked at laws changing chronologically over time, but what happens when laws conflict at the exact same moment in time?
Simultaneous collisions.
Yes. This brings us to the battle for supremacy. Parent versus subordinate legislation.
To understand these collisions, we have to look at the structural hierarchy of power.
Okay, lay it out first.
At the apex, you have supreme or parent legislation. This is the law passed directly by the primary sovereign body, like a parliament, a congress, a state assembly.
But a national parliament cannot micromanage the operational details of a society.
No, of course not.
They aren't going to debate the specific safety protocols for a local chemical plant or the exact dimension requirements for a municipal zoning permit.
The modern state is way too complex for that. So the legislature delegates.
They hand off the power.
Right. The Parent Act creates a broad philosophical framework and then explicitly delegates the authority to a subordinate body.
Like an executive agency, a municipality, or some autonomous board.
Exactly. And that body drafts the hyper-specific, granular rules. This creates delegated or subordinate legislation.
Okay, but the source outlines scenarios where courts actively strike down these subordinate rules.
They do it quite a bit.
My logical challenge here is, if the parent legislation explicitly granted the delegated authority the power to make the rules in the first place, why would a court intervene?
Because of boundaries.
Shouldn't the specialized local authority or the specific department know the operational realities better than a distant parliament?
They might know the operational realities better, but they are bound by a vital legal doctrine known as ultra-virus.
Which translates to beyond the powers.
Right. Think of it through a corporate lens. A board of directors allocates a budget to a division manager for software procurement.
Okay.
The manager uses those funds to sign a lease for a new warehouse.
Well, they can't do that.
Exactly. The manager had financial authority, yes, but they acted ultravirus. They stepped completely outside the boundaries of what the parent authority permitted.
So a subordinate body cannot enact rules that contradict the foundational logic of the parent statute that birthed it.
Exactly.
I was looking at the R versus Prince case from 1875 in the source, and to me, it perfectly highlights how this becomes a massive philosophical collision.
Oh, that is a wild case.
It really is. A local subordinate regulation banned the sale of intoxicating liquor to anyone under the age of 16.
Which, on the surface, sounds like a perfectly reasonable public safety rule drafted by a local authority.
It does. But the overarching parent statute of the land at that time had set the legal age of consent for marriage at 14.
Yeah, the disconnect is staggering.
It really is. The Parent Act is declaring that a 14-year-old is legally an adult capable of binding themselves in the ultimate adult responsibility marriage.
Right.
Meanwhile, the subordinate rule is arguing that a 15-year-old, who the state recognizes as a married adult, isn't mature enough to purchase a pint of ale.
And the court observed that philosophical contradiction and ruled the local regulation ultravirus.
So it wasn't just a disagreement over an age limit?
Not at all. The subordinate rule was actively subverting the parent statute's foundational definition of adulthood.
Wow.
In a clash of legal philosophies, the parent law's intent always reigns supreme.
And it isn't always about abstract philosophical clashes either.
True.
The text details cases where it's just a sheer power grab by the administrative state. Look at the Delhi Transport Undertaking versus BBL Hedgery case.
That is a classic example of subdelegation creating an accountability gap.
Explain that one.
So the Parent Act, the Delhi Corporation Act of 1957, explicitly designated the general manager as the sole authority possessing the power to appoint or dismiss certain employees.
So the legislature placed their trust and the legal liability squarely on that specific office.
Exactly, the general manager. But the subordinate rules drafted under the Act quietly allowed the general manager to delegate his firing power down the chain of command.
Down to an assistant general manager.
Right. And the Supreme Court immediately struck that subordinate rule down.
Because the Parent Act said the general manager.
Exactly. It didn't say the general manager or any middle manager he decides to hand the messy work to.
The court had to intervene because allowing that subdelegation would destroy administrative accountability.
Precisely. If the legislature dictates a specific chain of command, a subordinate body cannot just rewrite its own org chart.
And the source emphasizes that procedure matters just as much as substance in these turf wars.
Oh, absolutely.
The Banwarole versus State of Bihar case really stood out to me.
Yeah, that's a good one.
The subordinate rules drafted under the Mines Act were completely invalidated by the Supreme Court. And the wild part is, the court didn't even evaluate if the rules themselves were good or bad for the mining industry.
They didn't need to evaluate the content at all.
Why not?
The rules were struck down strictly because the Parent Act explicitly required the government to consult with a mining board before framing any regulations.
And the government decided to skip that procedural consultation.
They just skipped it. So because they ignored the procedural boundary set by the parent, the subordinate rules were essentially born dead.
It proves that procedure is an active safeguard against executive overreach.
It prevents administrative tyranny. The ecosystem relies on a very strict food chain.
Right.
The parent dictates not just what the subordinate can do, but the exact procedural pathways they must follow to do it legally.
This intricate web of parent and subordinate rules brings us to our final concept, which is, honestly, a bit of an administrative brain teaser.
It is.
We're looking at the reincarnation of a statute.
The legal framework's mechanism for self-preservation.
Yeah. We'd established how parent and subordinate laws fight, and we know from our first segment that a parent law can be totally wiped from the hard drive via repeal.
Right.
So what happens to the thousands of subordinate children? Rules, the local bylaws, the departmental forms, the municipal zoning codes, when the parent law is executed, but then instantly resurrected as a modernized new law.
Well, if the system didn't have a built-in failsafe, it would trigger complete administrative anarchy.
I can imagine.
The source points us straight to Section 24 of the General Clauses Act of 1897 to explain the solution.
Okay, what does Section 24 do?
It is a brilliant piece of legislative foresight designed to prevent systemic collapse.
Because without it, every single permit ever issued, every local committee appointment, and every safety regulation drafted under the old act would just vaporize the second the repeal happened.
Exactly. You would have thousands of public servants completely paralyzed, unable to enforce basic rules until new rules were drafted from scratch.
That sounds like a nightmare.
It would be. So Section 24 introduces a powerful legal fiction. It ensures that if a central act is repealed and then reenacted without major structural modifications, all those old appointments, notifications, orders, and subordinate rules survive.
So it's basically like tearing down an outdated, crumbling house and building an identical, slightly more modern house on the exact same concrete foundation.
That's a great analogy.
The law lets you move all your old furniture right back into the new house, assuming the couches still fit through the new doors. You don't have to go to the store and buy everything again.
That is exactly how it functions. By legal fiction, the old subordinate rules are automatically deemed to have been issued under the new reenacted provisions, provided they don't explicitly contradict the new text.
So they just seamlessly detach from the dead parent and attach themselves to the new host.
Right. It saves the government from having to rewrite and relitigate tens of thousands of pages of subordinate regulations every time they want to tweak a master statute.
So what does this all mean?
That's the big question.
We started out talking about the illusion of the law as a permanent structure, like a stone tablet.
Oh,
But looking at the life cycles detailed in Unit 5, we've seen it is an intensely mechanical process.
highly mechanical.
Laws are born, they evolve through substantive and procedural patches, they engage in brutal, hierarchical turf wars where courts strike down subordinate power grabs.
Yeah.
They can be obliterated completely, or they can be reincarnated, carrying their subordinate baggage into a new legislative life.
If we connect this to the bigger picture, it serves as a stark reminder of the fluidity of our legal reality.
Right.
Every contract you sign, every regulatory permit your business relies on, every right you assume is locked in, is actually tethered to this constantly moving machinery.
It's all moving.
Being truly well-informed requires looking past the surface text of a law and understanding the mechanisms of how it might be altered tomorrow. The ground beneath your feet is always shifting.
Which leads me to one final, slightly provocative thought to leave you with, derived from our exploration of implied repeal.
Oh, this is good.
We discussed how an old law can be silently assassinated simply because a newly passed law contradicts it.
Right. And the legislature never bothers to officially announce the old law's execution.
Exactly. The silent killers sitting in the statutes.
Just waiting there.
Think about the sheer volume of legislation passed every single year across thousands of jurisdictions. How many zombie laws are currently sitting on the books right now?
That's a scary thought.
How many of the rigid rules that we assume are governing our daily commercial and personal lives at this very second are actually legally dead, just waiting for a smart lawyer in a court case to point out the contradiction that killed them years ago?
Probably more than we want to admit.
Probably. So next time you look at a dense legal code and assume it's an immovable object, remember those zombie laws.
It is a living, breathing, and sometimes entirely hidden ecosystem.
Thanks for taking the deep dive with us.
Yeah.